Okay, well, look, I won't keep you waiting. Thank you very much for logging on time. We'll run through this. It's the first time we've actually presented this boardroom briefing on family trust, so you'll have to bear with us. But we'll see how we go, and hopefully we answer all of your questions, and otherwise that's what question time at the end is for. So let's dive in and see how we go. If I can if I can make it work. Why won't you come down? Come on. All right, hold on a second. It doesn't want to play ball. Zoom slideshow. There we go. Okay, so this is me, Melissa Healy. I'm one of the directors at DFK Everalls. We've got Jason Griffiths, my co-director, listening in, and unfortunately Rob Shelton's not able to join us today, but hopefully I think we've got a couple of other team members on board as well. Just the usual disclaimer. I'm doing a presentation today to talk to you about how family trusts are structured and ways that they could be used to improve your wealth, particularly outside of superannuation. There are a lot, and I mean a lot, of tricks and traps. So it's really, really important to note that this is very general information. It is not tailored for your particular circumstances. Please do not go and set up a family trust tomorrow without talking to us, okay? Because depending on your personal circumstances, it may or may not be appropriate, and there might actually be a better way of doing whatever it is you want to try and achieve. So please be careful. So tonight, what I'm going to be trying to talk to you about is, give you a rough idea of what a trust actually is, how they're structured, all the different components of it, the tax implications, because of course everybody's interested in the tax side of things. But then also I've got 10 case studies for you, very simple ones, but on how to use a family trust, whether that's for business purposes, investments, asset protection purposes, and even estate planning. So let's dive into it. And I do apologise, the slides are very word heavy. I make sure that you get, a lot of information, value for money for your time, so to speak. And I figure since you're all in front of a computer screen, you can actually read it rather than on the screen in the back of a room. So apologies. In terms of what a trust is, it's actually just a relationship between two people effectively, where a person is under an obligation to hold property for the benefit of other people being the beneficiaries. So the trustee is holding property on behalf of beneficiaries. And, the trusts date back hundreds of years, all designed, if you think back to the old days of trying to look after kids and that kind of stuff, trusts have been very popular on that basis, where you don't want to give control of an asset across to somebody, but you still want them to benefit from it. So the terms of the trust relationship are documented in a trust deed. So when you buy a family trust, so to speak, you'll get one. It'll come with a trust deed document. Technically, a trust is not a separate legal entity. The assets therefore have to be held in the trustee's name in trust for or as trustee for the trust. But the tax office does make it lodge its own tax return, and we'll talk more about tax implications later on. It lodges its own tax return, but it doesn't actually pay tax per se. And just a little thing to note, a trust can't exist forever. There's this, law against perpetuity. So it actually finishes on its vesting day, and that's usually 80 years maximum for most of the states, I think, except for South Australia. So what are the different types of trusts? We have what's called fixed unit trusts, fixed trusts or unit trusts. These are where the entitlement of the beneficiaries to both the income and the capital of the trust is determined by the number of units they've got in the trust. So unit holders normally buy units in the unit trust, and then that entitles them to their share of the profit of the trust. Okay, so the most common example of these are managed funds with, investment companies, or, managed funds are usually trust structures. So you buy units and in return, they'll send you a distribution every quarter or that kind of thing. So very useful where you need to have specific ownership, a specific share of the unit trust. Discretionary and family trust that this presentation is going to be talking mostly about is where the distribution of the income and the capital is at the trustee's absolute discretion. Now, what this means is that the beneficiaries have no specific entitlement or interest in the income or the property of a trust. So you can have a wide range of potential beneficiaries: mum, dad, kids, grandparents, siblings, aunties, all that kind of stuff, grandkids. And you can even have related entities such as, your son's company can be a beneficiary of your family trust because it gets related that way. So we'll talk in more detail in a second about that. But, the idea is that the assets are held by the trust for the benefit of the beneficiaries, but it's up to the trustee each year to decide which beneficiaries are entitled to a share of the income. So it's a bit like potluck. They have a right to be considered, but no specific right to receive anything. But that, of course, then has the benefit that you've got the flexibility to distribute to perhaps whoever's most tax effective each year. There's another kind of trust also called a testamentary trust. Now, these are different. These are trusts created by a will. So it doesn't actually exist until you pass away. So you can write your will now, set it up so that it creates a testamentary trust upon you passing away, but that trust doesn't exist until then. You own all of the assets for the moment. When you pass away, the assets will get handed over to the testamentary trust, and then according to the provisions in the will, the trustee of that trust will do what you tell it to do with those assets, kind of thing. So we're not talking about testamentary trusts today, but I thought I'd put that in there just to make it clear. That's not what we're talking about. So let's have a look at how a trust is actually structured. The starting point, how do you set up a trust, in other words? The starting point is that we have to find a settlor. The settlor is the person who initiates the setting up of the trust by providing the starting amount of trust property. Okay, so a trust doesn't exist unless there's actually property that's being held in trust for someone. Okay, the settlor is not allowed to be the trustee, and they're not allowed to be a beneficiary. So the trick with the settlor is to make it like a family friend or someone like that who's they have no responsibility, no role, no liability once they've signed on the dotted line to say, I want to set up a family trust for you. So, it's a very easy job to do kind of thing, but it is an important position. What happens then is, so that created the trust property. Now I'm going to, hold on 2 seconds, see if I can multitask. Sorry, here we go. So as we said, the critical thing then is that we actually have some trust property. When you set up a trust, we do from a practical point of view, we do this notional thing where the settlor notionally gives you $100 to set up a family trust for your family. Okay, that $100 then becomes the first deposit into the trust bank account. All right. Obviously, the trust is going to need more money than that. So what normally happens is that you then lend or perhaps gift the trust some money. And it can be cash to go into the trust bank account, or it can be specific investments that you can transfer across. But we just have to remember that the minute you transfer an asset, like you've disposed of it by giving it to the trust, that's going to trigger personal capital gains tax issues for you and potentially stamp duty. So just be careful on that front. All of the trust property, the assets of the trust, have to be bought in the trustee's name. The advantage with trusts compared to perhaps superannuation funds is that the trust can buy or have any asset that the deed allows it to. Okay, so the deed is that document that's going to set out all the rules of the trust. So that means a trust can buy or set up a business. It can own and run a business. It can have investments of any sort you like. There's no restrictions like a self-managed super fund has. And it also has the flexibility that there's no restrictions, for example, on the private use of assets. So, for example, a trust can buy a house that you can live in. Okay, you're not going to get a tax deduction for it, but it is technically possible. Now, having said that, again, we're talking about all the things that you could do, not necessarily the things you should do. The reason that you don't put your own home in a family trust is because then you lose the main residence exemption for CGT purposes, okay? But there might be asset protection reasons or something like that where perhaps one reason or another it's relevant. But again, there's probably other better ways of doing it. So anyway, so the trustee can help the trust buy anything it wants to, as long as the deed says that's okay. The trustee still, however, has the responsibility to to exercise skill and care in making investment decisions. So, you know, you can't be silly and you can't buy assets for the trustee's own personal use, because that would be a breach of fiduciary duty to the beneficiaries, for example. So obviously use common sense. A trust can also borrow money. So the settlor, for example, can put the $100 in, and then you can lend, or the bank can lend money to the trust to enable it to go and buy other assets or investments. So again, as long as the deed says that the trust can borrow money, it can do that. All right. Then what we have, trust of property. As I mentioned, the trust deed, that's the one that can documents all the rules of the trust. It talks about what the trust can invest in. It talks about the responsibilities of the trustee. It also talks about who the beneficiaries can be, which we'll talk about in a second. And it also says who the appointor is. It also creates the mechanism for changing these things, so changing the trustee or changing the beneficiaries. It also sets out all the administrative things, like so what the trustee is allowed to do and what they have to do. For example, they have to maintain financial records and financial statements and things like that. So that's what the trust deed does. What you need to be aware of is that it's really important to get the deed right the first time. If you have to go changing the deed, like changing the beneficiaries or sometimes changing the trustee, but that's okay. But updating the deed can actually trigger what's called a resettlement. And if the trust owns any capital assets, sometimes amending the deed causes a resettlement of the trust, so to speak, and that's a crystallization of the capital gains. So it can be a very expensive mistake to make. So you want to get that deed right the first time so that it doesn't need updating. So the trick is just to get that balance right between flexibility and detail. One of the big things that the deed will nominate is the appointor. Okay, so the deed creates this position of the appointor and what their powers are. The main role of an appointor is to actually appoint the trustee, who then manages the property or of the trust. If the trustee, it's a fine line because you're not allowed to fetter the freedom of the trustee to manage the trust appropriately. But what the appointer can do is have rights, for example, over appointing who the trustee is. So they can always change the trustee. Sometimes the deed allows the appointer to have control over the distribution of the capital of the trust. So that, the distribution of the income is at the trustee's discretion, but maybe the capital is decided by the appointer. Sometimes the appointer even has a power of veto. So the trustee can manage the trust however they like until the appointer says, no, you're not allowed to do that, kind of thing. And then the other common one is that vesting date. So as we said, most standard family trusts are set up with a vesting date of 80 years hence. There are ways documented in the deed of bringing that date forward and winding up a family trust when it's no longer useful to you. So sometimes you need the consent of the appointer to wind up the trust early. So that's the role of the appointer. And what you do need to make sure from an estate planning point of view is if you have a family trust that, for example, you're the appointer of, and you might even be the trustee of it. But if something happens to you, you have to make sure that your deed has a provision for appointing a new appointer who can then appoint a new trustee. So family trusts and stuff and estate planning are very closely related and definitely need to consider those together. Let's talk a little bit more about the trustee then. So the trustee is technically the legal owner of all of the trust property. So it's the trustee's name that appears on the title deeds, for example, or the share certificates on the bank account. But quite often the second line of the name is then, as trustee for whatever the family trust is. The important thing to note for the trustee is that they bear personal liability to all the creditors and of the trust. So if the trust owes any money and the trust runs out of assets to pay those creditors with, then the creditors can come knocking on the trustee's door. The same applies to the beneficiaries. There's a fiduciary duty of the trustee to manage the trust property for the benefit of the beneficiaries. If the beneficiaries think that the trustee has been negligent, for example, or reckless or breached the deed rules, then they can sue the trustee for damages. So on that basis, a trustee can be an individual person, or even two, or it could be a company. You can have a corporate trustee. We strongly recommend, even for plain old investment trusts, that they have a corporate trustee. It does make things a lot safer for the individuals involved, because then you get that layer of limited liability protection that a company offers. And it also means that, for example, hubby and wife can be co-directors and co-shareholders of the trustee company, but if something happens to one of them, then the trustee itself, i.e. the company, doesn't change, and therefore you don't have to muck around changing all the names on the title deeds and the share certificates and things like that. So it has both the risk asset protection purposes and administrative simplicity, having a corporate trustee, although it does cost a little bit more. As we said before, the trustee has to obey the rules of the deed and do what's required of it in there. There's also what's called the Trustees Act, in other words, trust law, that's been developed over centuries of court cases looking after trusts and issues associated with those. So the trustee has the responsibility to make sure it complies with all that law as well. It's just all the standard stuff like acting in the best interests of the beneficiaries, acting in good faith, exercising reasonable care and due diligence in managing the investments, that kind of thing. But yeah, you do have to remember there is that legal obligation to be aware of. Okay. Now, when we, sorry, my mouse has gone silly. Let's have a talk now about beneficiaries. So I'm just going to scoot down a couple. So everything I've just talked about is on these slides here that you'll have a copy of. And then we get to the beneficiaries side of things. Okay, so the idea is, if this test individual, for want of a better word, is, say that's you and your spouse, okay, you can go sideways to your siblings and their spouses. The beneficiaries, so when we're talking a family trust, of course, the tree also goes up, so your parents and their parents and grandparents, that kind of thing. And then, of course, it goes down to your children and your nieces and nephews, being the children, obviously, of your siblings, and any lineal descendants, for the next 80 years, so to speak, of this generation. So there's quite a broad range of people that can be potential beneficiaries. So when we set up the deed for a family trust, you have, you'll be nominated as the primary beneficiary, and sometimes there's secondary beneficiaries, but then there's the general beneficiaries, which is documented as all these people. Now, on top of real people, you can also have related entities. So if your child, parent, sibling, whatever, or even yourselves for that matter, have a related company, partnership, or trust, they can receive trust distributions from your family trust. So they can be a beneficiary of your family trust as long as they are controlled by one of these people. Okay? The other interesting thing that family trusts can do is, you're all aware that, in your tax return, you can claim donations for, money that you give to registered charities, what's called a deductible gift recipient. When you have a family trust, you can actually make, if your deed allows, you can make distributions to various charities and not-for-profit organisations. So, for example, including churches. Now, even what we're doing is not making a donation per se, because these guys aren't tax-deductible charities. What we're actually doing is giving a profit distribution to them. And beneficiaries have to pay tax on the profit that they're given, but because these are charities, they don't pay tax, so they get the profit distribution tax-free. But the point here is that you've earned this profit, you give it to a charity, you don't have to pay tax on it because you haven't received it, you haven't got that profit distribution, the charity did. So it's actually a very clever way of being able to make effectively pre-tax profit distributions to non-deductible gift recipients. Okay, so for those of you particularly into contributing to your church, or for example, some overseas charities aren't deductible Australian charities, so you can distribute to them. But there are some issues with non-resident stuff, so just bear that in mind. But anyway, so they're a possibility as well. So at the end of the day, it's the beneficiaries are as specified or potentially excluded in the trust deed. So you can actually word your trust deed to say, I'm the primary beneficiary, my spouse is the secondary beneficiary or whatever, and everyone else is the general ones, but I specifically exclude Uncle Fred because I don't like him. Okay, So you can actually exclude specific people if you so desire. The only thing to watch out for is that you actually have to have more than one beneficiary. In other words, if you're the trustee and the only beneficiary, well, you can't exactly hold assets for yourself. That's just a nonsense. So we need more than one beneficiary, potential beneficiary. You can distribute 100% to one all the time, but you need at least two. So there you go. That's the structure of how a family trust works and all the different components of it. So hopefully that makes sense. What I'd like to talk to you about now is the costs and admin issues of a family trust. Now, of course, how long's a piece of string? You've got a cost to actually establish. Sometimes it's as cheap as $500, but if you've got a corporate trustee, that adds on more. And of course, depending on how much advice and assistance you need, it can cost a little bit more to set up. And sometimes the Office of State Revenue wants to actually stamp the trust deed. You've got ongoing fees as well. You've got to do your accounting fees. There's financial advisor fees and an ASIC fee if you're going to be a corporate trustee. Admin wise, you need a tax file number for your family trust. And if you're running a business, you'll need an ABN, GST, PAYG, Rego as well. You obviously need a separate bank account, and just remember that you need that annual trust distribution minute signed before 30th of June each year. So the trustee has to decide before 30th of June each year how they're going to split the profit for the year. Now, obviously not to the cent, because we don't know what we've earned yet because it's not 30th of June, but we can say, well, I want mum to have the first 50 grand and kids to get $400 each, and I'll take the balance, that kind of thing. If you don't have that trust distribution minute signed before 30th of June, all of the income of the trust is taxed at 47%. So it's really important to be careful. All right. Tax implications. Sorry, that's all your cost and admin stuff there. Tax implications, as I said before, you don't have a separate legal entity per se, but it does need to lodge a tax return, decide how the profit's split. The profit gets split between the beneficiaries. The beneficiaries declare that income in their personal tax return, and it just goes into another box. So you've got your salary and wages, your interest, your dividends, and you've got your trust distribution for the year. Add it all up, compare that to your marginal tax rates, and the tax office sends you a bill for that tax. If any franking credits came with your trust distribution, then you'll get a credit for those as well. Unfortunately, kids under 18 aren't terribly helpful because they're only allowed $416 gross income, including franking credits, and anything more distributed to them will be taxed at 47%. But having said that, there are ways, particularly if your kids are a bit older and they're going to be turning 18 soon, there are creative ways of utilizing them sooner. The income distribution gets credited to the beneficiary's loan account. So, for example, you might have been spending money on their behalf during the year, or they might have been taking money out during the year. In the financial statements, we record that. Then we record the distribution that they get for the year, and whatever's left over, they can take the following year. The important thing to remember with trusts is that losses are not distributed. Losses get quarantined in the family trust. So if you have bright ideas about negatively gearing an investment property, for example, inside a family trust, that only works tax effectively if you've got other investments in there earning income that you can then offset against the negatively geared rental property. Otherwise, the losses will just carry forward until such time as the trust has made a profit, and then it will use those up. Okay. So that's an area you do need to be really, really careful of. The other tax implications to bear in mind, trusts are good from a CGT point of view, There is this thing called a family trust election. I won't bore you witless, but just bear that in mind, particularly if you do have losses or franking credits. If you're thinking about transferring a personal asset into the family trust to kickstart it or move it or whatever, just remember that does trigger personal CGT and potentially stamp duty issues, as I said at the beginning. The other thing to watch out for is that property owned by a trust is not eligible for the main residence exemption. So as I said, don't go putting your own home into a family trust, because then, at the moment your own home is CGT free when you sell it. But if you put it in a family trust, you lose the main residence exemption, and the family trust will pay capital gains tax on any profit on sale. And the other thing to watch out for is that then makes it subject to land tax as well. And the worst part is land tax. ACT's good because it's got land tax applies to everybody evenly, consistently. Other states have a land tax-free threshold, but it doesn't apply to family trusts. So if you own a property in your own name, I can't remember the thresholds, $500,000 in New South Wales, it'll be tax-free, and then they'll tax it a little bit. Family trusts don't get that benefit. You'll get the land tax payable from the first dollar of value. So be careful, really take that into account, because that's going to be an extra expense compared to owning it personally, for example. All right, so that's roughly the first half on how a trust is structured and the tax implications. What I'd like to do now is run through some examples of how to use a trust. Now, obviously, given the time involved and all the rest of it, we're going to keep this fairly light, but we've got question time afterwards if you've got any specific issues. So there's a few different ways to use a trust. They can be used to own a business. They can be used to own investments. You can, and the investment side, obviously, there's, some tax efficiencies of doing that sometimes. Trusts can also be used for asset protection purposes and even estate planning. So let's have a look at some case studies about different ways you could use a family trust. Now, going back to that initial warning, please take a deep breath, okay? Do not race out and do these. There is lots of fine print. There are lots of different ways you can skin a cat, so to speak. So depending on what you want, using a family trust might be appropriate, or maybe there are more cost-effective, simpler ways of doing it that are more tax-effective and that kind of stuff. But this just gives you some ideas. Do not implement without talking to us. All right. Just briefly talking about businesses. You can run a business through the family trust. It's been done forever. You still get to maintain control of the business by being the trustee or being the directors of the trustee company. You can use that corporate trustee to give you that limited liability protection that you would normally get if you just traded straight through a company. It's great because whatever profit you make, you can just decide from year to year how to split that profit between your family members, potentially depending on how much other taxable income they've got, for example. So that can be very tax effective. Obviously, a family trust can still employ family members to do real work and pay them market rates and the superannuation to go with that. And we also note that running a business through a family trust can be more tax effective for CGT purposes, although it's a lot more complicated to prove that you're eligible, but compared to holding a business in a company name. So again, depending on your business and when you think you might sell it and how much of a capital gain you think you might be able to get on it, that might be important or not. The things you need to watch out for running a business through a family trust are that, say the alternative is being a sole trader or perhaps being a company. By running a business through a family trust, your setup costs are higher because you need both to buy a family trust and you need to buy the corporate trustee. So there's just that little bit extra setup costs. You need to watch out that in a company, for example, the company earns income, pays expenses, has net profit. As a business, it pays 26%, as a small business, I should say, it pays 26% tax, and it has therefore 74% left to either reinvest or to pay out to you guys as dividends. If you have a family trust, all of the profit needs to be distributed. And if you're a high income earner and don't have any low income earning beneficiaries to distribute to, you're probably paying tax on that profit at 47%. If you need to leave the money in the trust to reinvest back into the business, that means you've only got 53% left to lend back to the trust, whereas in a company structure, you might have 74% left to give back to the trust to reinvest. So from a cash flow kind of point of view, that can have a big impact on your cash flow. As we said before, remember that losses are quarantined in a trust. So if you think, for example, that your business is going to go through a couple of years of building up and things are going to be tight or that kind of stuff, you just have to be really careful, because those losses will be quarantined in a family trust. Whereas, for example, perhaps as a sole trader, those losses could be offset against your other income, depending on specific rules and all the rest of it. But so those losses will just carry forward until such time as the trust does have a profit to use up those losses against. Now, the other thing to watch out for, though, with a business is it's really only good to use a trust for a business if it really is genuinely a family business, because there's not going to be any specific proportion owned by the trust. The trust will own the business. The trustee manages the business and inside the trust, and it's completely up to the trustee as to who gets the income and who gets the capital. So you can't, as a beneficiary of the trust, for example, you can't say, I own 25% of this trust, unless it's a unit trust. But you can't do that with a family trust. And what it therefore means is that you can't sell 50% of your business to somebody else because it's not yours to sell, so to speak. You need to change the structure. So this issue, of not having the specific proportion owned makes it challenging. And if you're thinking about, progressively admitting new business partners or doing a succession plan with your team members, management buyout, that kind of thing, you just simply can't do that with a trust. So the solution there might be actually using a combination of structures. So perhaps your business is in a company and the shares in that company are actually owned by your family trust. So your company makes a profit running the business and then pays a dividend up to your family trust. And then your family trust can decide which beneficiaries get what share of that income, for example. And your company can then, your family trust can decide to sell 50% of its shares in the company to somebody else. And that way the business, the company, ends up being owned by, 50% by your family trust and perhaps 50% by somebody else's family trust, or whatever works for them. So those are the things you need to watch out for running a business through it. When we look at investing, just investing, passive investments, buying shares and managed funds, real estate, that kind of thing in a family trust, the advantages of a family trust are that they're great if you need access, simply because it's not locked up until retirement like it would be if you contributed the money to a superannuation fund. Family trusts also have their advantages. For example, if you already have a $1.7 million transfer balance cap on your super fund, in other words, you've already reached the max, you can't put any more money into super, so where do you put it that's tax effective? Chuck it in here. Obviously, if you've got low income earning family members you can split with, and also if you have vulnerable beneficiaries to look after. So let's have a look at some case studies just in a fraction more detail on that. So as I said, perhaps you need access before age 60. So you put the money into a family trust, you accumulate inside the family trust, and it pays you the income. You can retire at age 55, for example, and then for the next 5 years live off the money in the family trust until age 60, when you can access your pension. So they're very handy in that respect. As I said before, if you've already got 1.7 million in super and you can't put any more in, well, then you might as well park it in a family trust, or that's one of the options, where perhaps it can be, be more flexible. The other thing is, you might not have hit 1.7 yet, but if, for example, you've had a windfall in an inheritance or something like that, you've met you've put your 27,500 in for the year through your employment. So this is concessional contributions and non-concessional contributions, the before tax and after tax contributions into super. If you've already done your 27,500 for the year, and perhaps you've done the 3 years bring forward, so you've put $330,000 into your super fund and therefore can't put any more in for the next 3 years, then parking the money in the meantime into a family trust until the next 3 years rolls around and you can move some more across into your super fund. So a family trust can be a handy place to park the money in the meantime, perhaps tax effectively. And then, of course, if you've got, the alternative, if you can't put more money into super, you can just invest it in your own name. But the problem there is that usually means 47% tax. So therefore, investing in a family trust gets you that flexibility to be able to distribute the profit, perhaps to some low-income beneficiaries, or maybe even park it in a bucket company, as we call it, to get the benefit of the lower tax rates. So expanding on that, here's the retiring with more than 1.7 million in your fund. This is another way of doing it. When you do get to retirement, so your super fund can keep growing even if there's 1.7 million in it now. If you're not retiring yet, the 1.7 can stay in accumulation phase until you are ready to retire. When you're ready to retire, you start your pension with your first 1.7 mil. Then normally the excess has to stay in the accumulation account, but it's going to get taxed at 15%. So perhaps if you've retired and therefore have no other income, or you've got some low income family members, then maybe the trick is that you start that pension with the first 1.7 million, but rather than leaving the excess in the accumulation account, maybe we take that balance out as a lump sum, move it into a family trust, so that the income, you invest it inside the family trust, and whatever income it earns, you can then distribute that to the low income earners effectively tax-free. The first 20, 30 grand can be tax-free, particularly in retirement. So there's a great use for a family trust if you're going to be hitting that 1.7 mil. Here's just the simple income splitting idea, but just with some numbers so that you can see the dollar effect, and therefore perhaps work out when one might be appropriate or not. But say you've got $500,000 to invest, you've got an inheritance, or sold a business, something like that, sold a rental property. Say you've got $500,000, even at 5%, that's earning 25 grand. If you invest it in your own name, that 25 grand is going to be hit with 47% tax. So that's $11,750 per year, every year, that you're going to be paying tax. The alternative is to put it in a family trust. And if you can distribute that 25 grand to a low income earning beneficiary, now, whether that's a spouse or an adult child who happens to be studying or on maternity leave, etc., looking after kids, even if just part-time, their tax rate's got to be lower than yours. you could end up in a position where the tax is nil, in which case you've saved $11,750 every year, or even if they're part-time or have some other income and their tax rate's 21%, including Medicare levy, they're only paying $5,000 tax on that. So you're still saving $6,500 every year. Okay. So, investing via a family trust gives you that flexibility to choose year on year which beneficiaries you're going to give to. So, your adult children, as they progressively turn 18, they're still at uni, but you can distribute $50,000 a year each to them and pay, peanuts in tax. And then as that one graduates and gets a job, well, then you start distributing to the next one in the line, that kind of thing. So yeah, it gives you a lot of flexibility. And of course, periodically you're going to have a big lump sum capital gain from the sale of an investment, swapping out some shares or something. So it also gives you that flexibility to distribute that to a lower income beneficiary at that point in time. This is the bucket company gap year strategy, as I call it. So same idea, you invest $500,000 in your own name, you're going to be paying that $11,000 tax. If you invest it via a family trust, say you and your spouse are both working, you don't have any kids to distribute to or low income people, that's still okay. Distribute it to a corporate beneficiary, a bucket company as we call it. Being an investment company, it has to pay 30% tax, but even then that's only $7,500. So you're saving $4,000 tax a year by distributing to a corporate beneficiary. The idea then is that $500K is growing from a capital investment point of view. There's capital growth on that. And of course, the $25,000, perhaps net of tax, is growing inside, definitely net of tax, is growing inside the company. Then when you get to age 55, that's when you take that accumulated profit and potentially cash in some shares and make a capital gain. All of that can then be distributed to you as a fully franked dividend, for example, over that 5 years, to help you pay for your living expenses, and you live off the family trust money until, for example, age 60, when you can then access your superannuation. So, a brilliant way of, being able to retire early, but still have money to live on. I've kept these examples really simple, but obviously whenever you, depending on what you invest in, but if you invest in managed funds or shares, there will be franking credits associated with that. And then depending on your tax rate, those franking credits can either be used to help pay the tax bill, or if your income's low enough, you'll actually get a refund of those franking credits. So you could have a situation where the company's paying this 30% tax year after year after year, but then when it pays you the dividends, you actually get a refund of those franking credits if your personal marginal tax rate is less than that. So that's that one. Now, another area where family trusts can be quite helpful, they're family trusts for a reason. We want to use them to help support our family, particularly if we're lucky enough to have more than we need to live on. So let's have a look at how we can do that. I suppose there's your traditional family trust, perhaps where the trust distribution, hang on 2 seconds. Oh, it's got dark all of a sudden, sorry. You've got your traditional family trust where the profit is notionally distributed between beneficiaries, but for all intents and purposes, it's just family money. So, your 18-year-old that you distribute to, they never actually see the money, and there are legitimate ways we do that. But actually, sometimes there's times when you actually want the money to go to the kids. This not saving it until the grave idea and sharing it while it's useful to them and while they can take advantage of it. So one of the ideas here is, for example, even if you had an adult beneficiary earning 100 grand a year, the boss is going to be putting 10% super in. There's 10 grand. I've kept it simple. How about we give them a profit distribution of 15 grand for the year? Now, that's taxable income to the beneficiary. But what happens if they make a personal deductible superannuation contribution then into their super fund and claim a tax deduction for it? So 15 grand comes in, 15 grand goes out to the super fund. The two offset each other in the tax return. And so no tax is payable personally on that superannuation, sorry, on that money that they've received from the family trust. Now, of course, don't forget that being a concessional contribution into the fund, the super fund's going to take 15% out of it. But again, 15% is probably better than your 47% or even their 47%. And the money that's now inside the superannuation is hopefully working hard for them and only getting taxed at 15% going forward. Again, much better than their marginal tax rate. So it's a way of sharing wealth with your adult children, but still protecting it a little bit in terms of they can't spend it. So, there's no choice but to have it invested. And perhaps it lets them, focus on paying off their house debt instead, but they'll at least have a nice superannuation fund when they do get to retirement age eventually. But, that's, of course, if you want to give them help paying off their house, well, that's fine. You can give them the profit distribution. They've got to pay tax on it, and they'll have the net left over to be able to, for example, make a dent in their mortgage. So whatever works for you guys. Here's a really creative one. For those of you who've got kids who are good at saving up, but are obviously starting young, this one, again, be really, really careful, but it's just an example of how creative you can be. If you've got a adult child presumably, who wants to buy a rental property but only has, for example, a 10% deposit. If the parents, for example, have financial resources, perhaps they buy the other 90%, so they go into buying a rental property 90-10, and then the child can progressively buy the rental property off their parents, and that way they're doing it without actually borrowing money, so to speak. The issue, so it's a good strategy, but the problem is it triggers capital gains tax every time they buy a 5%, 10%, 20% share off the parents. So, and that causes stamp duty issues each time and record keeping, and it's a bit painful. So there is actually a way where you can set up a family trust. The kid lends the trust 10%, the parents chip in 90%, and that's effectively as a loan to the family trust, and the family trust then buys the property. At the end of every year, the profit gets split 90-10, and what happens is that as the child progressively saves up, they lend more and more money to the trust, and the trust uses that money to repay the parents. So you get to the stage where instead of being 90-10, it becomes 80-20 and 70-30 and 60-40 and 50-50 and that kind of thing. And until you get to a stage where effectively, notice the bold print, the child owns the whole property. And what you've done is transition ownership of the property effectively to the child without triggering any capital gains tax. Okay, it's the capital gain is all still there, and somebody will need to pay tax on it. But you haven't had the paperwork and the mucking around in the meantime. Now, the fine print there is that there is a lot of risk involved in doing this, and you need to have a lot of trust within the family to make it work properly. Because remember how I said a beneficiary doesn't have a specific proportional entitlement to the assets of the trust. A beneficiary cannot say, I own 20% of the trust. It can't even say I own 10% of the trust. So this needs to have a solid family relationship to make sure that the profit gets distributed according to how much each of them have chipped in. And you've got to have that agreement on how the value is going to be done and things like that. So it's doable, but you need to be really careful. And of course, note that there's land tax issues owning property in a family trust rather than in your own name. That lack of no tax-free threshold, which if you're talking New South Wales, Queensland kind of property, is a big issue. And also note that we're not talking about borrowing any money. So if mum and dad have lots of spare cash lying around, so to speak, or are interested in buying a property, that's fine. But it's not a structure that needs debt. So yeah, just something creative to think about. Trusts can also be used for an asset protection point of view. Sorry, I'm running a few minutes behind schedule. The idea here is that you can protect trusts from personal bankruptcy. You can protect trust assets from personal bankruptcy unless you control the trust. And you can do it the other way around. You can protect your personal assets from the trust going bankrupt. So for example, if the trust is running a business, but you do have to watch out for those guarantees. So I've got a case study on that in just a second. The other thing is from a family law point of view. The thing with family law is that, again, because the trust assets aren't yours personally, they don't get treated as part of the matrimonial pool of assets to be divided up upon property settlement, unless, of course, you've got legal or de facto control of the trust. But it's amazing how many people who are about to get divorced go and change the trustee to their parents or their brother or that kind of thing. But what the family court can do is treat those trust assets as a financial resource, and they will therefore be considered when determining the division of all of the other property. Okay, so I can talk to you in more detail about that later on. But with all things, watch out for the loan account. So like in the previous example, where you have lent money to the trust so that it can buy a business or buy investments, that loan is a liability of the trust. It owes you that money. Therefore, it's your asset because the trust owes you money. And that asset can still be taken into account for both bankruptcy kind of purposes and family law purposes. So just be careful you don't shoot yourself in the foot on that front. So just a simple case study. Option 1, Fred runs his business and has personal assets. If his business goes broke, so I'm talking, sole trader kind of thing here, such that Fred is held personally liable, then the liquidator takes his personal assets. So obviously not good. The option, therefore, is for Fred to keep running his business, but make sure his personal assets are held inside the family trust, of which his wife is the trustee. So the trick here is that he doesn't control the trust and therefore has no say on the income and the assets, because that's the trustee's job. And therefore, when the business goes broke or gets sued because of an accident, Fred presumably gets held personally liable, but the liquidator can't touch those assets because they're held by a family trust because the wife is trustee. So very handy from an asset protection point of view. So whether it's a business or even just a high-risk industry where there's a chance that you can be sued personally, very important to consider asset protection issues. Here's another way of looking at asset protection, particularly for your vulnerable beneficiaries. Fred's son, George, for example, has issues, shall we say. That could be anything from being a spendthrift, you don't like what he spends his money on, gambling, drugs, etc. But he is your son. He needs money to live on, but you don't want to be having to manage his day-to-day, week-to-week cash flow. He doesn't want to have to keep putting his hand out to you all the time. So there's a potential to put assets into a family trust, whether that's cash, investments, or even a home for him to live in. The money's invested and then used to pay a regular income stream to George. Presumably he doesn't have any other income, and therefore, the first 25 odd grand is going to be tax-free anyway. The advantage of doing this is, remember how beneficiaries do not have a specific entitlement to income from the family trust or from the capital. That's owned by the trust and managed by the trustee. So it means that George can't get his hands on the other, the capital of the trust. So it's protected from George doing silly things with the money. He just gets his paycheck, his pocket money, and he can live off that, but without being able to access the capital. And of course, then from a succession planning point of view, if Fred was to pass away, a new trustee can be appointed to continue looking after the investments and therefore George. So that's another way a trust can be used for asset protection purposes. Now, I've mentioned before about how you don't want to put your main residence into a family trust because you lose the main residence exemption for CGT purposes, and you end up having to pay land tax on it, which obviously we'd like to avoid if we don't have to. So what happens if we've got mum and dad, both high income earners, high risk individuals running a business, or high risk industries where there's a good chance of getting sued or something? There's an opportunity to set up a special purpose family trust where mum and dad can get a loan from the bank. Say they've got $1 million equity in their house, $500,000 equity, whatever. They borrow money from the bank using that equity as security, and they gift that money to a trust. The trust then lends it back to them. So it's a gift on one hand, end of story. It's not my money anymore. But then the family trust lends me the money back. So I now owe the trust money. And the trust has given me that money that I need to pay it back. But I use that money in the meantime to pay off the bank. So I borrowed money from the bank on Monday and I pay them back on Tuesday. So you've got to do a special deal with the bank, obviously. It's a loan for a day. But the point then is that instead of owing the bank money, I now owe the trust money. And the trust therefore wants to secure that, and it registers a mortgage over the house as security. So definitely, don't need to pay interest, don't need to make loan repayments, because this is just a private arrangement, nothing to do with tax. If there ends up being problems, i.e. there's a chance you're about to be sued, the trust calls in the mortgage and says, oi, I want my money back. You sell the house, use the money to pay back the loan to the trust, and then the trust has that money. The point being that you don't have that money anymore, and therefore the creditors who are trying to sue you don't get access to that money. So it protects your equity in the house. The trick is that you need to remember to redo that as your equity progresses. So, every 100 grand or 200 grand that your house increases in value, you've got to remember to remortgage, reborrow, borrow another $200,000 out and update your documents accordingly. But, this can be very handy when you've got both mum and dad in high risk industries. Remember, this is nothing to do with tax. This is purely asset protection. There's no tax deductions for interest or anything like that. So that's just another creative way you can use family trusts. Last but not least, sorry, I'm running a few minutes over time. Estate planning. Oops. The important thing here, as I said, the trust assets are not personal assets. They're owned by the trust. They're held in the name of the trustee, so they don't go through the will. Even if the trustee dies, all that happens is we get a new trustee. And what that means is, because they don't go through the will, they can't be contested. But what that therefore means is they don't go through the will. So you need to make other provisions. So you need to make sure that your trust deed allows for a new trustee, to be appointed by the appointor. If the shareholder, if the person who died was a shareholder of the corporate trustee, then their will needs to say who's going to inherit that share in the corporate trustee, for example. And what you have to remember is that whoever is the shareholder of the corporate trustee gets to decide who the directors are, and the directors are then the ones who manage the trust. So that's how you transfer control of a trust, perhaps to the next generation or to your spouse or something after you pass away. So let's have a look at a specific case study. Say Fred's got 2 kids from a previous marriage and wants to ensure they get an appropriate distribution from his estate. What he does is puts some assets, the appropriate assets, in a family trust of which he's the trustee, but he hardwires the trust deed so that if he passes away, then the 2 kids become the replacement trustees and therefore inherit effectively control of the assets within the trust. And then they can decide what they want to do, whether they want to keep the trust going or whether they wanted to wind it up and take the assets. Okay, so the assets are owned by the family trust and therefore they don't go through the will and therefore they're not contestable. And also there's no CGT or stamp duty payable on the change of the trustee. The trust still owns those assets. That hasn't changed, therefore there's no CGT or stamp duty. It's just the trustee at the top that's changed. Now, similarly, Fred could also do this the other way around, or both, in terms of he can put other assets into a different trust with the new wife as replacement trustee, for example. Now, again, this is what you could do, not necessarily what you should do. There are other ways of managing this through binding death benefit nominations and things like that with your superannuation. There's ways of doing it through insurance, beneficiaries of insurance policies. So again, just highlighting this is one of the ways you can achieve your goal, not necessarily the only way. So again, just be careful on that front. So yes, overriding warning, they're just examples of how a family trust could be used. Please get advice. There might be cheaper, easier, more tax effective ways of structuring your investments, depending on your personal circumstances and your goals. And if you get it wrong, there will be nasty CGT and stamp duty consequences. So how can we help you? Our job as your financial advisor is we want to look at your personal circumstances, what obligations you've got, future goals and aspirations. So that's, do you have house renovations you're saving up for? Do you have kids' school fees that you want to pay for? Do you want that gap year or 2 or 5 between finishing work and accessing your superannuation? Do you have low income earning beneficiaries that you can trust to distribute income between? Do you have more than enough money that you've got some spare that we can use a trust to effectively distribute money to your kids while you're alive, and while, when they can use it, when it's really helpful to them, rather than leaving it as a lump sum inheritance. So, we want to help you make informed decisions and develop that strategy and that plan and keep you on track for achieving those goals. So on that basis, thank you very much. Apologies for running over time. Are there any questions? You can put them in the chat box or unmute yourself if you're brave and want to talk to me. We will be sending out a link to the recording afterwards. That only usually takes us a couple of days, and you've hopefully already got a copy of the slides. Now, I think, was it Louise? Let me start at the top. So the question is, if one has a family trust set up to own shares in the family business, is it best to keep it for that purpose and not to do other things with the family trust? Good question. I suppose it depends what the business is up to. Normally, shareholders are protected from any problems with the family trust. So it is effectively just an investment. And if the company goes broke, you know, the family trust loses its shares, and that should be it. So the generic rule is, yes, it's okay. But there might be specific circumstances in your case that might make me cautious. So come and have a chat to us in more detail. Can a corporate beneficiary also be a trustee? Yes, a corporate beneficiary can be a trustee, definitely. Sometimes not recommended, because again, if the trustee is the one who's responsible and can be sued, the whole idea is we wanted that limited liability. Like, we want an empty corporate trustee so that if it gets sued, you lose your $2 and that's the end of the story. If it's a corporate beneficiary and it's received lots of money and that's accumulating in the corporate beneficiary and it's also trustee, then it places all of those assets at risk as well. You also have the complication that perhaps the corporate beneficiary then starts investing its money, or, you know, it's obviously got a bank account to receive trust distributions. So how do you tell the difference between which bank account or which investments are owned by the corporate beneficiary in its own right versus which ones does it hold in trust for the trust? So I know it's a pain to have the extra cost of setting up an extra company and the administration costs of managing that company, but it is much, much safer to have them separate. So technically you can, but don't. Please don't. Okay. Going back to that original question, it's still, yeah, it's still fine to have a corporate, yeah, whether you've got a corporate trustee or a personal trustee, as long as the trust only owns shares, it should be protected. So it doesn't matter if you have other investments in there, but again, personal circumstances makes me worried. The cost of financial advice. Good question. It depends. So the financial planning rules post Royal Banking Commission and things like that. And it depends what sort of financial advice you're after. So accountants can provide some advice, in which case we'll probably charge you an hourly rate or give you an upfront quote for setting something up if you know what you want. If you're talking about financial advice from the point of view of managing a portfolio of investments, then financial planners are the ones who are licensed to provide specific investment product advice. They tend to charge, depending on how much money you've got, what you want to invest in, how actively you want it managed, that kind of thing. But they can charge anywhere perhaps from 0.5% to 1% of the value of the investments. Sometimes they'll charge fixed fee, but that gives you a sort of an indication of the range that they might be interested in talking about. But the problem with, or the challenge with financial planners is they are going to do a really, really good job of drilling down and making sure that whatever financial strategy they come up with for you covers everything. They're going to be looking at your income, your investments, your family, your goals, your asset protection requirements, your estate planning. And it's that initial statement of advice up front that can cost a little bit of money to get organized, but it's so worth it, because then you have that really clear roadmap of exactly how you're going to achieve your goals. And if they can double your money in 10 years kind of thing, and make it tax effective in the process, minimize your tax in the process, which then leaves more money in the investment pool to grow. It is so worth it. Thank you, Ian. Super saver. Yes, so there's definitely a strategy available. So to refresh memories, there is this thing called the First Home Superannuation Saver Scheme, where people can make extra superannuation contributions into their fund, and then when they find the home of their dreams, they can withdraw that money out of the super fund, not the compulsory employer part, but any voluntary contributions they put in. They're able to withdraw that money and use that as a deposit on their home. It's good. You get a tax deduction for the money going into your super fund. The earnings are only getting taxed at 15%, whereas if you invested that in your own name, maybe you're paying 34%, 47%. So it is a tax effective way of doing it, but just be really careful, because the fine print on withdrawing money back out and the timing of when you exchange contracts and all that kind of stuff. So there is fine print, so just be careful. All right. In relation to using a bucket company to catch profits, which you aren't ready to distribute, yeah, can you have another family trust as yeah. So yeah, this is tricky. So you can have your family trust and the beneficiaries are mum, dad, and a company, and the company is related to you guys. What you can actually do is have the bucket company owned, the shares in the bucket company owned by the family trust. So it can do a profit distribution down to the bucket company if you guys don't want the money yet, because you're on 47% tax rate. You accumulate it in the bucket company, and then the bucket company accumulates all of that money, and when you're ready, it then does a fully franked dividend back up to the family trust, and then the family trust distributes, that's income for the year, so the family trust then distributes that out, but this time it distributes it back to mum, dad, kids. So yeah, you can definitely do that. Don't do it on a necessarily revolving basis, because that then just gets a bit silly, but it's definitely doable and a good strategy, particularly when that then gives you the flexibility that if mum and dad don't retire at the same time, so for example, plan A might have been to own the shares in the bucket company 50-50, but if one retires earlier than the other one, then you obviously don't want to split the dividend 50-50, so recycling it back up to the family trust so that you can distribute it to the right person is definitely clever. With dividing profits. Okay, Phil. So yeah, we've already said that when you distribute the profits from a trust, it goes to the beneficiaries and they have to declare that trust distribution in their personal tax return. What then normally happens is that you end up on the quarterly PAYG installment system. So the ATO says, hang on a minute, you're getting this trust distribution every year. Instead of waiting until when you lodge your tax return, I want quarterly installments as we go. If you use that trust distribution to make a personal tax deductible contribution, then effectively you've got a trust distribution coming in and a tax deductible contribution coming out. So yes, the two offset each other so that you don't have to pay tax on that trust distribution. So that definitely works. The thing to watch out for, though, is that the maximum amount per person is the 27,500 concessional contribution cap, and and that includes your employer contributions. So if your boss is putting $10,000 of super in, then you can only put another 17,500 in. So just be careful on that front. All right. Okay, John. There are no tax implications per se of gifting money to a trust if you're gifting cash. Yeah, so you can do whatever you like with your cash because presumably it's after-tax cash. So you can gift that to the family trust to get the ball rolling, not a problem. The issue is simply when you have a rental property or some shares and you want to transfer those to the trust, that's fine. You can gift them to the trust and the trust receives them and says, thank you very much. But you personally have disposed of an asset, an investment, and therefore you have to pay capital gains tax on that, whether the trust gave you any cash to pay that with or not. So you've just got to be really careful that you don't go distributing, gifting assets to a trust and then incur a personal tax bill, but you've got no cash left to pay the tax with. So yeah, just be really careful on that front. It does remind me though, Centrelink does get cranky at you gifting more than 10 grand a year or 30 grand in a 5-year period, I believe. So don't go gifting stuff thinking that you're going to get away with offloading assets for Centrelink purposes. Luckily, I'm not a guru on Centrelink. Starts from 4, yeah. Bob's just mentioned there that financial advice from our financial planning team of Everalls Wealth Management starts at $4,000, but you'll get very comprehensive advice for that. Now, if a corporate trustee is set up and purely as corporate trustee, because it doesn't earn any income in its own right and it doesn't incur any expenses in its own right, no, it does not need to lodge a tax return. So we tend to tell the ATO up front that it's only a trustee company and therefore won't be lodging tax returns, so they don't hassle you. Thank you, Jimmy. Okay, so as I just said, the corporate trustee doesn't need a tax return and therefore doesn't need financial statements, although I know some accountants, or in the old days we used to do them. The annual cost of looking after the tax and compliance, the preparation of the financial statements for a trust and preparing the tax return, again, it's how long's a piece of string. It depends on what you're invested in. It depends on the quality of your records. But for example, we can set up a family trust with a zero data file and you can process the transactions in there. Our fees tend to be around about the 2.5 to 4 grand mark for most of our investment trusts. If your trust runs a business, well, of course, it depends on how complicated the business is. So again, that can be from 2.5 grand to 7.5, 10 grand, just depending on how much help you need on that front. No worries, Gary. Thank you. Does the super fund? Yes, superannuations funds. That's what your, so Helen has asked about super funds and tracking the pre and post tax dollars. Yes, super funds do that. That's why you get an annual statement each year. On that annual statement, they will be able to tell you how much of your superannuation money is pre-tax and how much is post-tax. Anything that is post-tax, you'll get back out completely tax-free. Anything that went in pre-tax gets charged the 15%, and then as long as you're over 60, that all comes out tax-free as well. Oh my goodness, we're there. Okay, any other questions? Was that okay? Sorry, went over time. If you've got any questions, feel free to email me during the week or give me a call if you're shy and don't want to talk tonight. We'll be sending out the recording and the slides. Thank you very much for coming. If you have any suggestions on what other topics you're interested in, if there was a component of tonight, do you want to learn more about testamentary trusts, for example, or do you want to learn more about asset protection or whatever, more detail about family trusts, I don't know, please do let us know. Thank you, Woon. Thank you, Jimmy. Thank you, John. Thanks, Bob. All right. All right. Yep. So if you need any more detail, don't hesitate to give us a call. Thank you very much. Good night.